Our first case today, cases, Lori Johnson, the Ohio Department of Job and Family Services, and Ricky D. Morris versus Ohio Department of Job and Family Services. Well, I guess each party will have 15 minutes to present their arguments on the first case. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know, as I will be keeping track of the time. The arguments are being recorded, so please stay behind the podium and keep your voice up. You should not use the names of children or minors or victims or folks that should not be mentioned by name. You can refer to them by initials or terms like the child. The judges have read the briefs and are ready to proceed when you are. And would you like to reserve some time?
Yes, Your Honor, if I may, 5 minutes for rebuttal.
Okay, you may proceed when you're ready.
Thank you. May it please the court, Lawrence Reinhold, I'm the guardian and the attorney for Lori Johnson in this matter. The relevant facts, as I see them, are on July 28, 2017, the Summit County Common Police Court Probate Division ordered that Lori Johnson be transported to Wyatt Woods Care Center and to remain there until further order of the court. There are 4 issues, as I see it, in the case, and they're kind of separate but interrelated. And they really go to the heart and purpose of the probate court. The first one is the relationship or the interrelationship between the PASAR, which is the pre-screening, the pre-admission screening and resident review that's conducted by the Department of Health, versus the orders of the probate court. That's what gave rise to the appeal, is that the PASAR determined that Lori should no longer reside at Wyatt Woods. They said that she didn't meet the standard of care for a nursing home. The problem, as I see it, is that it's a direct conflict with the powers and the duties of the probate court. The duty of the probate court is to protect the ward and to provide for their maintenance and support. I think that's exactly what they did when they ordered her to Wyatt Woods. And I think also the matter reflects on the exclusive jurisdiction of the court, of the probate court, or the probate division of the Common Pleas Court, because it's a matter that touches the guardianship. And the Supreme Court says that the probate division has exclusive jurisdiction over matters that touch the guardianship. And it touches the guardianship because, like I said, it refers to the maintenance and support and care of the ward. And the court has determined that that's the appropriate placement. The PASAR says it's not, so there's a conflict. In terms of the question is whether the PASAR can overrule the court.
The PASAR just deals, if I understand correctly, the funding of who's going to pay for the ward to be in the nursing home, is that correct?
That is correct.
So if there were funds available, private funds, and she wanted to stay in the nursing home, the court wanted her to stay in the nursing home, she could continue to stay there. Is that accurate?
Absolutely. It only arises because they're cutting off the funding to the nursing home so that the nursing home would move to evict her and the problem would arise.
In this case, I take it there were not sufficient funds for Ms. Johnson to stay in the nursing home on private pay?
Correct. That is correct. In terms of the decision about where she stays, like I said, I think it creates the problem because the probate division is saying she should be there for her safety. And as we just pointed out, the PASAR just determines whether or not the state should pay for her to stay there. And they determined that they shouldn't pay, which would result in her eviction from the nursing home. The other issue I think that we have to address is the relationship between the appeal and the Common Pleas Court. It's my argument that the probate judge erred in not hearing the appeal, because I think both under the Ohio Constitution and the statutes, the probate court has the power to hear an appeal from the administrative agency. The statute doesn't refer to appeals to the general division, it just refers to appeals to the Common Pleas Court. And obviously in some counties, there's only one court that it appeals In others, they're divisions. Here, they're divisions. I'm
I
not
believe that
arguing.
under 2101-24, I believe it would set up the exclusive, the jurisdiction of probate court. How do you think it falls, this appeal would fall under the jurisdiction of probate court under that statute?
Because it touches, as the Supreme Court said, it touches the guardianship. Because it determines whether the ward will continue, where the ward will live.
But
and
all
how the
matters
ward is-
involving the ward are not brought in probate court. If someone sues for breach of contract, if there's a foreclosure, those matters are heard in the common pleas court, if I recall correctly. Is that accurate?
It depends on whether or not it touches the guardianship. There was just a case that we didn't brief because it relates to accounts, but the 8th District ruled that the probate court does have jurisdiction over accounts because it touches the guardianship.
Bank accounts and those type of things, you say accounts or retirement accounts or?
No, we're talking about like debts, like
Okay.
the bills. If they had a credit card debt that they didn't pay and they get sued, then the probate court has jurisdiction over that because it touches the guardianship, because it touches the ward, it touches the funds, and it touches, it's kind of sloppy in a way because in bankruptcy, when they file a petition, they say it creates an estate. And it's specifically set out in the statute that there's an estate. Here, it doesn't really say that, but it does because, in reality it does because the probate court has interim jurisdiction over the ward and the property, the houses, the money, the funds, and all that stuff. And so there is an estate. So I think if it touches the ward or the estate of the ward, I think the probate court has jurisdiction. And I think it does in this case because, like I said, we're talking about providing medical care, we're talking about, the nursing home facilities, the medicines, the food, and all the other things that the nursing homes provide for the ward, and I think that's important. The flip side of that is really that the general division lacked jurisdiction, and I think, and I cited the John Winnick case, because what it basically is doing is you have an order of the probate court for Lori to live in Wyandotte Woods. The appeal to the general division of the common pleas overrules that order by saying, no, she doesn't belong there. So if you have two, they talk about it, coordinate jurisdiction, courts. So even assuming that it had jurisdiction to hear the appeal, it still can't render the decision because it's contrary to the Winnick case because it's basically overruling the probate court's decision as to where she should live. Like I said, the same is true for the placement, viewing the placement order separate and distinct from the appeal. The general division can't overrule the order. And I think that's the problem. Obviously, this court could. But I don't think that the common pleas general division can overrule or meddle in the guardianship of the probate division. And I think that's what this whole scenario created, was a conflict between who decides. First between the PASAR itself and the nurse that did it, as to whether they can vacate the order or ignore the order or whatever of the court. And then secondly on the appeal. So, that's, my position is that it really should be remanded to the probate court for the appeal, because obviously if it's in the probate court issued the order, it has jurisdiction. If it changes its position as the superior guardian, which it has the right to do, and rules that Lori no longer needs to be at the Wyandotte Woods, that resolves the matter.
Well, does the probate court have the authority to order the facility to have Lori remain there?
I believe it does. It creates a very interesting problem. All of the problems in this case are created because she's indigent. If she had money and she was private pay, they would never even do the PASA, because it's only designed basically to throw people out of the nursing homes because it's cheaper, to keep them in a group home than it is in the nursing home. So that's really its design. But I think the court could.
So if she was in a facility but not under a guardianship, and past our review came up, and they said she's not eligible, no longer, I don't want to get into that section. The appeal happens to the general division of the Court of Common Pleas, right? She's just not under guardianship?
Well, it could, unless there was some other reason, under the statute or under the Constitution, why it would go to another division. But I guess by default, it could go to the general division because it would have general jurisdiction.
So does that mean that individuals who are going through this review process, if they're under guardianship, they may have greater ability to remain in the facility because of the orders of the probate court?
Yes, I think that's absolutely correct because of the nature of the guardianship. I mean, you're dealing with an incompetent person and you're dealing with a court that oversees that person. So in a lot of ways, it's just like a juvenile. It's just like paren, pariah, or whatever, they look out for the well-being of the person.
Counsel, I need to let you know you are into your rebuttal time.
Oh, I'm sorry.
That's okay.
Um,
You can continue.
But I think it provides more protection for them because they're incompetent, which I think is the whole design and purpose of the probate court, is to protect them, and in just circumstances such as these. No further questions.
Okay, you will have 4 minutes and 20 seconds for your rebuttal.
Thank you.
Morning, may I please the court? Becky Thomas on behalf of the Ohio Department of Job and Family Services. The purpose of PASAR is to make sure that folks with serious mental illness and/or developmental disabilities are kept in the least restrictive setting possible where their needs can be appropriately met. Federal law, in order for nursing homes to be Medicaid certified, requires this process to be applied to everyone who's in a nursing home who has, or there's a suggestion that they have a history of serious mental illness or developmental disability. They have to be evaluated. If they're found not to have those conditions or situations, then the PASAR process stops for them because it's designed only for those two groups of people. But if they are found to have either developmental disability or a serious mental illness, and there's no dispute in this case that Ms. Johnson had a serious mental illness that has not been argued or disputed anywhere along the way, to my knowledge, she had to be evaluated under this process. It's required by federal law for certification. It actually has nothing to do with funding. Despite what my friend on the other side says, if she were private pay, the exact same process would have happened because she's in a facility that's Medicaid certified, and that's what makes the difference. Nobody can stay in one of those facilities if they're in one of those two populations and don't need nursing home services or meet the 30-month exception, which is that they've been there for at least 30 months and have been found to need what's known as specialized services for either developmental disabilities or serious mental illness. The probate court does not have jurisdiction over appeals from these decisions. It doesn't actually touch the guardianship at all. There is a guardian, but that doesn't mean that everything that happens to the ward automatically touches the guardianship. The guardian has no discretion in this matter, neither does the probate court about who can stay, because it's black letter law that if a person is a member of one of these populations and doesn't need nursing home services or meet the 30-month exception, that person cannot remain in a nursing home if it's Medicaid certified. They cannot, under any circumstance. The law governing probate courts and guardianships in particular says explicitly that the revised code is the limit of the power. There may be other limits too, but it is a limit of the power that a probate court or a guardian has to control or take action on behalf of a ward. They cannot do something that's contrary to the revised code. And placing someone indefinitely in a nursing home that's Medicaid certified is against the law, against that law, because this process has to be performed, and if it comes out with the result that it did here, the person must be discharged. Now, they're not just tossed out. They have to go through a process, the facility and other, some government entities are involved in proceeding with a safe, what's known as a safe and orderly discharge under Revised Code 3721.16. That's also governed by federal law. And the federal statute that governs that and the pass-out process itself is 42 USC 1396 RE7. And the subparts of that are, I'm not trying to remember those, but we've cited it in a brief, and they can be accessed online. And they explain what the pass-out process is, that statute, that's in the code, the US code. It explains that a person who is found to have either SMI, serious mental illness, or developmental disability, and doesn't need nursing home services, and doesn't meet the 30-month exception, must be discharged. There are no exceptions. The rule-out process just means that they were found in the initial stages not to have SMI or developmental disability. That's all that means. There's no ruling out for any other purpose, except, well, there's some dementia-related exceptions that we've cited, but there's no argument here if there's been a diagnosis of dementia, so that doesn't come into play. So there's no way that Ms. Johnson could stay in the nursing facility unless there was something wrong with the decision that the Department of Mental Health and Addiction Services made. There's been no argument that that decision was incorrect. There's been no argument that the level of care was different than the department found it, and there is no argument that Ms. Johnson met the 30-month exception, or even that she needed specialized services. There's no assignment of error on that basis. There's no argument about that being wrong and being a basis for reversal. As I understand the arguments from my friend on the other side, it's about probate court jurisdiction versus the general division, and about the probate court's placement order. The probate court's placement order should be read as a whole and should be read as a limited order, because otherwise it violates the statute that requires this, the resident review process. And so the court did make clear that it was basing its decision on the fact that there was an emergency, there was an immediate harm risk, and that the nursing home had agreed to take Ms. Johnson, and it's really more in the nature of an involuntary placement or an ordered placement for safety in the short term. It should be read not to violate the law. I don't think there's anything in there that requires it to be read as contrary to the law, but if it is read that way, the court did not have jurisdiction to do that.
We would agree the law gives a ward or any individual who's in a nursing home the right to appeal to a common pleas court if they wish to challenge the finding, in this case, that they don't qualify, correct?
Yes.
Is your argument that the statute that says it can be taken to the common pleas court in general excludes probate court, or that the 2101.24 that sets up probate court's jurisdiction excludes probate court from where the appeal should go?
If I understood that correctly, the probate court, there's nothing in the probate court statutes that I've seen that indicates that the probate court can hear this appeal. And the reason that's given by my colleague is that it touches the guardianship. As I've explained, our position is it does not touch the guardianship. This process would proceed regardless of whether there was a guardian. Things that touch the guardianship, especially in ways that my friend is talking about, are things that impact the discretion that can be exercised and the control that can be exercised by a guardian. None of that comes into play here. The guardian has no power to make any decision about whether she stays or not. It's in the law. This process is applied. If she doesn't qualify, now if she were to stay there, sure, there could be decisions about food and medical care and kind of room and furnishings and all those things. Those come within the guardianship, but the fact that she doesn't qualify because she doesn't meet either of the two possibilities is just a part of the revised code that has nothing to do with the guardianship or the probate court, and it would proceed exactly the same way whether or not she had a guardian. So that's how I think we know that it doesn't touch the guardianship at all. The case that my friend was discussing from the 8th District, if that was about accounts, that's no surprise to me that it touches the guardianship, because that's one of the things that guardians do. They control the accounts, they make decisions about it, and those decisions would be overseen by a probate court. Sure, that comes right in the province of a guardian's powers and duties. I don't believe that the fact that the probate court's placement order was raised at the agency level. I don't see it in the record. the agency record that was certified to the court, and I don't see it in any documents, and you mentioned in the decisions by the agency. So I suspect that this was not brought to the attention of the people making the decision at ODGFS on appeal.
Would they have cared? Would they have cared that probate court made an order that said she should be there under the pass order termination? That wouldn't really be relevant, would it?
It wouldn't affect the outcome, Your Honor, but I think it affects my friend's ability to raise the argument on appeal.
Agree with that. But if it had been done, it wouldn't have mattered to the decision maker on the administrative level. They wouldn't have given any weight to the fact that probate court said she should be there.
So it's hard to know exactly what individuals might have done, but I would say that it shouldn't have made any difference.
Under the administrative code, it has no weight. Whether they gave it weight or not, there's nothing under the code that said it should have weight.
I think that's right, because that order should be read as a limited time order and not as something that the court didn't even have jurisdiction to do in the first place, which was to place someone with a history of mental illness in a Medicaid certified nursing facility indefinitely or permanently, just not within the probate court's power. Just say a few more words about why this couldn't be in the probate court. My colleague filed this appeal, or called it a filing of an appeal, inside the guardianship under that case note. As I think he's made clear, that was an in-rem proceeding. The appeal from one of these decisions is an adversarial proceeding, and the standards between those two proceedings would be diametrically opposed. There's a reliable, probative, substantial evidence and in accordance with law standard that goes along with the appeal under 5101.35. That comes from 119.12. And there's the best interest standard that's applied in a guardianship proceeding. And all decisions and actions made are to be in the best interest of the ward or the ward's dependents, depending. That's in the guardian statute 2111-13, I believe, or 15, it's one of those two. The record that the court would be allowed to consider would be confined to the agency record. The court would have to somehow leave everything else in the case out of consideration. That would be unworkable, if not impossible. The docket priorities would differ. 119.12 requires that the case be given very quick attention. So, and I think it's clear from the statutory language in 5101.35 and 119.12 that an appeal filed under those statutes is its own separate case. And the only time that this became its own separate case was when it was sent over to the common police court, and then also docketed with the correct caption with ODGFS as the appellee, which is another jurisdictional requirement for those appeals. So if this was to go forward anywhere, the only successful iteration of the case or incarnation of the case was in the common police court. And so for that reason, we would argue that that's an additional reason why it couldn't have gone to probate court here, and actually didn't go to probate court anyway. It wasn't even properly filed here. If there are no further questions.
Can you briefly comment upon the merits of the decision that was made in this case, in case we do reach the merits? Was the decision correct in this case?
Sure. So there's no dispute that I've seen from my friend on the other side about whether the decision by the Department of Mental Health and Addiction Services was on its merits correct. Ms. Johnson was found not to meet the level of care required to be in a nursing home. She didn't need the kind of services that a nursing home provides. And that has to do with, does she need hands-on assistance with activities of daily living? Does she need, does she have physician's orders for skilled nursing care or rehabilitation services? Does she have a condition requiring 24-hour care, supervision, or monitoring? Is she psychologically stable, psychiatrically stable? And the only thing that she was found to need from the list of things in the level of care was medication administration, which by itself is not enough to have someone need nursing home level services. And they also specifically found that she could obtain that help in a community setting in some way, like perhaps from home visits, home health aid visits, and nurse visits. And they found that she did not need specialized services for serious mental illness. That's a defined term. We've briefed that. And she had not been there for at least 30 months anyway, so that exception couldn't apply on either prong. That's the whole of what had to be reviewed to see if she could stay in a Medicaid certified nursing facility. And as I said, there's been, to my understanding, no dispute about those things anyway, so they have not been preserved for appeal. We ask that you affirm the court's two decisions that are being appealed. Thank you.
Thank you.
Yes, if it please the court. First of all, in terms of the record, I am certifying as an officer of the court that the court's order in this case, as well as medical records and other things in the Ricky Morris case, were sent to the hearing officer. Now, I have no idea in the world, there's no clerk or anything that certifies, there's no file stamp copy there. It was sent to them, it was argued to them as part of that was really the basis of the argument in the state hearing, and the appeal of the state hearing, was that the court's order supersedes the PASAR review. In terms of whether or not she could stay there voluntarily, I didn't cite it in the brief because I didn't think it was totally relevant to the issues here, but you have the Supreme Court case in Olmstead, which was the Georgia case where the state wanted to keep people in the nursing home and the ward wanted to get out. And basically the court said that they can't restrain them. However, it said that if the person wanted to voluntarily stay, they could. So if that's a concern or an issue, I think we could brief that to the court in supplement. But in terms of what the court's responsibilities are, I think it's to control the ward, to make sure the ward is protected and provided for, and I think it has an ongoing duty to do that. And it also has the ongoing duty to look at the least restrictive alternative as part of its duties as the superior guardian. And I think there's a constant review. And if the court no longer felt, or the nursing home no longer felt that Lori should be there, then it has the ability the court can change its order. But until then, unless something comes forward, there's nothing to show that there was a significant change or that the court changed its opinion. And in terms of the appeal, also we filed a motion to dismiss in the Common Pleas Court for lack of jurisdiction. So I think I've preserved the issue of the jurisdiction of the General Division of the Common Pleas Court. And I think it would have been preserved anyway in the Probate Division, but I think it was preserved through the motion to dismiss in the General Division. If there are no further questions from the court.
I think I would like for you to, if you would, counsel, address my colleague's question that he posed, should we get to the merits. Are you arguing that there is some indication that the decision was incorrect?
My argument is that there was nothing to show that the probate court, or the division of the probate court, that its position had changed. And as guardian, there was nothing to show that the position should change and that the least restrictive alternative was appropriate.
What do you make of the notion about it being limited and an emergency order?
It may have been an emergency order under Title 51 because it grants the court, they can issue ex parte orders to protect the ward now. But then once, 2 weeks I think after, pretty close to that, after this order was issued, the guardianship was issued, then it still becomes a question for the court whether or not the order should be vacated. It then becomes whether the guardian feels that at least a less restrictive alternative is available to the ward. Then I think the procedure would be for the guardian to apply to the court to vacate the order. I think it still exists because the situation, until the situation changes in reality, her condition improves and there's a safe, less restrictive alternative for her, then it's the responsibility of the guardian to apply to the court to vacate the order and have her moved to a less restrictive alternative.
Thank you. Thank you both for your arguments in this case. We will take the matter under advisement, issue a decision in due course. The courts will mail a copy to you on the day that that decision is released, and the opinions will also be posted on the Ohio Supreme Court website.